Imagine you're driving home late at night. The road is quiet, the headlights stretch out in front of you, and everything feels routine. Then suddenly red and blue lights flash in your rearview mirror. Your heart rate jumps. Instinctively, you start thinking about everything you might have done wrong. Were you speeding? Did you miss a signal? Is there something wrong with your car? You pull over to the side of the road. The engine idles. The officer's patrol car stops behind you, lights still flashing, illuminating the inside of your vehicle in pulses of red and blue. In that moment, most drivers assume something very simple. The officer is allowed to do whatever they want during this stop. But what if that assumption is wrong? Before we go any further, think about this question for a moment. If a police officer pulls you over during a traffic stop, what do you believe they are legally allowed to do? Can they search your car without asking? Can they make you step out of the vehicle? Can they question passengers? Can they keep you on the roadside for as long as they want? Take a moment and think about your answer. And if you've ever experienced a traffic stop yourself, share your experience in the comments. What happened during the stop? And did you feel like you understood your rights at the time? Because the truth is something that surprises many people. Traffic stops are one of the most common interactions between citizens and law enforcement. In the United States alone, tens of millions of drivers are pulled over every single year. For most people, these encounters last only a few minutes. A quick conversation, a warning, or a ticket, and then everyone goes on their way. But behind those few minutes on the side of the road lies a complex body of law shaped by decades of court decisions, constitutional interpretation, and real-world policing. What police can legally do during a traffic stop is not determined by guesswork or personal opinion. It is determined by the Constitution, by statutes, and by landmark rulings from courts that have examined these situations in extraordinary detail. And many drivers have never been taught these rules. To understand why traffic stops work the way they do today, we have to start with a basic principle that sits at the center of modern criminal law, the balance between public safety and individual rights. On one side of that balance is the responsibility of law enforcement to protect the public, enforce traffic laws, and investigate crime. On the other side is the fundamental protection against unreasonable government intrusion. In the United States, that protection comes primarily from the Fourth Amendment, which states that people have the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Those words may sound abstract, but they carry enormous consequences, because when a police officer pulls you over on the road, something very specific has just happened under the law. You have been seized. Not in the dramatic sense we see in movies, but in a legal sense. Courts have repeatedly ruled that when an officer activates their lights and signals a driver to pull over, the driver is no longer free to leave. That moment becomes a seizure under the Fourth Amendment. And that single legal concept triggers a chain of rules that governs everything that can happen next. But here is where things get interesting. For a traffic stop to be lawful, the officer does not need absolute proof that you committed a crime. They only need something called reasonable suspicion or probable cause, depending on the situation. Probable cause is a higher standard. It means there is a reasonable belief that a violation of the law has occurred. For example, if an officer sees a car clearly running a red light, that observation alone can establish probable cause for a stop. Reasonable suspicion is slightly lower. It means the officer has specific, articulable facts suggesting that a law may have been violated. Courts have emphasized that this suspicion cannot be based on a vague feeling or a hunch. It must be tied to observable facts. Perhaps a vehicle is weaving between lanes. Perhaps a brake light is broken. Perhaps a driver appears to be speeding. Even a minor traffic violation can legally justify a stop. And this is something many drivers do not realize. Traffic laws are incredibly detailed. Something as small as failing to signal properly, having an obstructed license plate, or driving with an expired registration can legally justify an officer pulling a vehicle over. In fact, the Supreme Court addressed this issue directly in a landmark case called Warrant v. United States in 1996. In that case, plainclothes officers in Washington, D.C. stopped a vehicle for a minor traffic violation. During the stop, they discovered illegal drugs inside the car. The defense argued that the traffic violation was merely a pretext. They claimed the officers were actually suspicious about other crimes and used the traffic rule as an excuse. The Supreme Court ruled unanimously that the stop was still lawful. The court explained that if an officer has probable cause to believe a traffic violation occurred, the stop is valid regardless of the officer's subjective motivation. That ruling has shaped modern traffic enforcement in profound ways, because it means that even very small violations can open the door to a lawful traffic stop. Now imagine the moment after you pull over. The patrol car door opens. The officer approaches your vehicle. Most drivers feel a natural sense of uncertainty at this point. People often wonder what they are required to do and what is simply a request. Legally speaking, the officer is allowed to approach your vehicle and ask for specific documents. Typically, those documents include your driver's license, vehicle registration, and proof of insurance. Courts have consistently recognized that these requests are part of the normal mission of a traffic stop. But here's something that surprises many drivers. The officer can also legally ask you to step out of the vehicle. This authority comes from another major Supreme Court case called Pennsylvania versus Mims, decided in 1977. In that case, an officer stopped a driver for an expired license plate. The officer asked the driver to step out of the car. When the driver did, the officer noticed a bulge under the driver's jacket and discovered a firearm. The defense argued that ordering the driver out of the vehicle violated the Fourth Amendment. The Supreme Court disagreed. The court concluded that the safety interest of the officer outweighed the minimal intrusion of asking a driver to step outside the vehicle. As a result, officers across the country were given clear legal authority to ask drivers to exit their cars during a traffic stop. And the rule didn't stop there. Years later, the Supreme Court expanded this principle in Maryland v. Wilson in 1997. This time the question was about passengers. Could officers also order passengers out of the vehicle during a traffic stop? The court ruled yes. Again, the reasoning centered on officer safety. Traffic stops are unpredictable situations, and courts have recognized that officers face significant risks when approaching vehicles. So under current law, officers may legally instruct both drivers and passengers to step out of the vehicle during a stop. Now pause for a moment and think about this. Before hearing this, did you believe police had the authority to make everyone step out of a car during a traffic stop? Or did you assume that was only allowed if someone had done something wrong? Let me know what you thought before learning this, because understanding these rules helps remove some of the uncertainty that often surrounds police encounters. But stepping out of the vehicle is only the beginning of the legal framework governing traffic stops. Another important issue arises almost immediately after that initial interaction. How long can the police legally keep you there? This question reached the Supreme Court in a case called Rodriguez v. United States in 2015. In that situation, a driver was stopped for briefly drifting onto the shoulder of the road. After the officer completed the tasks related to the traffic violation, he continued to detain the driver in order to conduct a dog sniff around the vehicle. The delay was only about 7 or 8 minutes. But the Supreme Court ruled that the extension of the stop was unlawful. The court explained that a traffic stop may last only as long as reasonably necessary to complete its mission. That mission typically includes checking the driver's license, verifying registration and insurance, running warrant checks, and issuing a citation or warning. Once those tasks are finished, the driver must generally be allowed to leave unless new, reasonable suspicion of criminal activity has emerged. This ruling established an important boundary. Police cannot extend a traffic stop indefinitely just to explore unrelated suspicions. But if new facts arise during the stop, such as the smell of alcohol, the odor of drugs, or inconsistent statements, then the situation may legally evolve into a broader investigation. And this is where many real-world encounters begin to become more complicated. Because the roadside is not a courtroom, decisions unfold quickly, often in seconds. Officers observe behavior, ask questions, and make judgments based on their training and experience. Drivers, meanwhile, may feel nervous, confused, or uncertain about what is happening. And sometimes those two perspectives collide. So the next question becomes crucial. What about searching your vehicle? Can police search your car during a traffic stop without a warrant? The answer is more nuanced than many people realize, and the legal reasoning behind it goes back nearly a century. But to fully understand that rule and why vehicles are treated differently from homes, we need to look at a series of court decisions that created what is known as the automobile exception. And that story begins with a case from 1925 that permanently changed the way vehicle searches are handled in American law. That case would eventually shape thousands of roadside encounters across the country, and it's something most drivers have never heard about. In 1925, during the era of Prohibition in the United States, alcohol was illegal to manufacture, transport, or sell. Law enforcement officers across the country were searching for ways to intercept illegal shipments moving between cities. One day, federal agents stopped a vehicle traveling along a highway between Detroit and Grand Rapids. They suspected the car was transporting illegal liquor. Without a warrant, they searched the vehicle and discovered bottles of whiskey hidden inside. The case eventually reached the Supreme Court, and the question before the justices was simple but profound. Did the Constitution allow police officers to search a vehicle without first obtaining a warrant from a judge? Normally, the Fourth Amendment requires a warrant for searches. A judge must review evidence and determine whether probable cause exists before authorizing police to search a person's property. But the justices recognize something unique about automobiles. Unlike houses, vehicles are mobile. If officers had to stop, find a judge, request a warrant, and then return to the scene, the vehicle and any evidence inside could easily disappear. The court ruled that under certain conditions, police may search a vehicle without a warrant if they have probable cause to believe it contains evidence of a crime. This ruling became known as the automobile exception to the warrant requirement. Over the decades, courts have repeatedly reaffirmed this principle. The reasoning has remained largely the same. Cars move quickly. Evidence can vanish. Because of that mobility, the law allows officers to act more quickly than they could when dealing with a fixed location like a house. But the key phrase in that rule is probable cause. Officers must have a reasonable belief, based on facts and observations, that evidence of a crime is inside the vehicle. This is where things often become interesting during real traffic stops, because probable cause can arise from many different observations. Imagine an officer approaches a car and immediately smells the odor of alcohol coming from the driver's breath. That observation could create probable cause to investigate a possible DUI, or consider a situation where an officer smells the odor of marijuana coming from inside the vehicle. In many jurisdictions, courts have ruled that this smell alone can create probable cause to search the vehicle. But laws about marijuana have changed significantly in recent years, and that has complicated how courts interpret those situations. In states where marijuana is legal, the odor alone may no longer automatically justify a search. This is one example of how legal standards evolve as laws change. Another common factor that can lead to probable cause is visible evidence. If illegal items are clearly visible inside the car, perhaps sitting on the passenger seat or the floorboard, officers may legally seize them under what is called the plain view doctrine. The logic behind the plain view rule is straightforward. If an officer is lawfully present and can clearly see evidence of a crime without conducting a search, the law does not require them to ignore it. Now think about the typical layout of a traffic stop. An officer walks up to the driver's window. From that position, they can see much of the vehicle's interior. If illegal items are sitting openly within view, those items may immediately change the legal landscape of the stop. But there is another scenario that often raises questions. What if the officer asks for permission to search your vehicle? This is one of the most misunderstood aspects of traffic stops. Police officers are legally allowed to ask for consent to search a vehicle, even if they do not have probable cause. Consent searches are a well-established part of American law enforcement. However, the key requirement is that consent must be voluntary. Courts have repeatedly emphasized that consent cannot be the result of coercion or force. If a driver voluntarily agrees to the search, officers may legally proceed without a warrant and without probable cause. But this leads to a practical question many people wonder about. Can you say no? Legally speaking, yes. A driver has the right to refuse a consent search. If consent is denied and the officer does not have probable cause or another legal justification, they generally cannot search the vehicle. However, if probable cause exists for another reason, the search may proceed regardless of consent. This is why many traffic stop interactions involve officers phrasing the request politely. You may hear something like, "Do you mind if I take a quick look inside your vehicle?" To some drivers, the request may sound casual, but legally, that moment can carry significant consequences, because once consent is given, the search becomes lawful even without other justification. Let's pause for a moment and consider this from a human perspective. Imagine you are standing on the roadside at night with flashing lights behind you. An officer asks if they can search your vehicle. Many people feel uncomfortable refusing. Some drivers worry that saying no might make the officer suspicious. Others simply assume they have no choice. But legally, consent searches rely entirely on the driver's voluntary agreement. Have you ever been asked that question during a traffic stop? If so, what did you decide to do? Moments like that highlight the psychological complexity of roadside encounters. People often make decisions quickly under pressure, sometimes without fully understanding the legal context. Another situation that sometimes occurs during traffic stops involves police dogs. Drug detection dogs have been used in law enforcement for decades. These dogs are trained to detect specific odors associated with illegal substances. But their use during traffic stops has also been examined closely by courts. The Supreme Court addressed this issue in a case called Illinois versus Caballes in 2005. In that case, a driver was stopped for speeding. While one officer wrote the ticket, another officer walked a drug-sniffing dog around the vehicle. The dog alerted to the presence of narcotics, and officers subsequently searched the car. The defense argued that using the dog violated the Fourth Amendment. The Supreme Court ruled that the dog sniff itself did not constitute a search under the Constitution, as long as it did not prolong the traffic stop beyond the time reasonably required to handle the traffic violation. This decision created a clear rule. If a drug dog is present and the sniff occurs during the normal duration of the traffic stop, it is generally allowed. However, as we discussed earlier with the Rodriguez decision, officers cannot extend the stop simply to wait for a dog if the tasks related to the traffic violation have already been completed. These legal distinctions may seem technical, but they shape thousands of real encounters every day. Another important aspect of traffic stops involves questioning. Officers often ask drivers a variety of questions during a stop. Some questions are directly related to the traffic violation. Others may be more general. For example, an officer might ask where you are coming from or where you are heading. Legally, officers are allowed to ask these types of questions during a traffic stop, but drivers also have constitutional protections related to self-incrimination. The Fifth Amendment protects individuals from being forced to testify against themselves. This protection is most commonly associated with the famous phrase, "the right to remain silent." However, that phrase usually arises during custodial interrogation, which is different from a typical roadside conversation. During a routine traffic stop, courts have generally allowed officers to ask questions without first issuing Miranda warnings, because the driver is not technically under arrest. That said, drivers are not required to answer every question beyond providing identification and necessary documents required by law. In many jurisdictions, drivers must identify themselves and present a valid driver's license when requested by law enforcement during a lawful stop. Failure to do so may result in additional legal consequences. But beyond those required documents, the scope of questioning can become a gray area where individual rights and law enforcement practices intersect. Another factor that often shapes traffic stops is officer safety. Law enforcement training places enormous emphasis on safety during roadside encounters. Traffic stops occur on busy roads, often in unpredictable conditions. Officers approach vehicles without knowing who is inside or what might happen next. Because of that uncertainty, courts have allowed officers certain precautions. For example, officers may conduct a limited pat-down search of a driver or passenger if they have reasonable suspicion that the person may be armed and dangerous. This type of search is sometimes referred to as a Terry frisk, named after the Supreme Court case Terry v. Ohio, decided in 1968. In that case, the court ruled that officers may perform a limited pat-down of outer clothing for weapons if they have specific, articulable reasons to believe the person may be armed. The purpose of this search is not to look for evidence of crimes, but to ensure safety. The search must be limited in scope and focused on detecting weapons. Over time, this principle has been applied to many types of police encounters, including traffic stops. And yet, despite all of these legal frameworks, traffic stops remain one of the most debated areas of law enforcement. Some drivers believe officers have far too much authority during these encounters. Others believe strong police powers are necessary to maintain road safety and investigate crime. The courts, meanwhile, continue to refine the balance between these perspectives. Every new case adds another layer of interpretation to the Constitution. And the roadside remains one of the places where those interpretations are tested most often. But there is one moment during a traffic stop that can dramatically change everything. A moment when a routine stop suddenly becomes something much more serious. It happens when an officer asks a question that many drivers fear hearing. "Would you mind stepping out of the vehicle for a moment?" Because depending on what happens next, that simple request can lead to anything from a warning ticket to a full criminal investigation. And understanding how the law treats that transition is one of the most important things drivers rarely learn. The flashing lights behind you fade into the distance as you finally merge back onto the road. The traffic stop is over. The officer has returned to their vehicle, and you are once again free to drive. But the experience tends to linger in your mind for a while. Your hands relax on the steering wheel, and you start thinking about what just happened during those few minutes on the side of the road. For many drivers, that moment of reflection raises a quiet question that often goes unspoken. Did everything that happened during that stop follow the law? And just as importantly, did you understand what your rights were in that moment? Traffic stops are one of the most ordinary interactions between citizens and law enforcement, yet they sit at the intersection of some of the most important constitutional principles in modern society. In just a few minutes, a roadside encounter can involve questions about the Fourth Amendment, the limits of police authority, the rights of individuals, and the practical realities of public safety. What makes these moments especially interesting is that they rarely feel like legal events when they happen. There is no courtroom, no judge, no lawyers arguing constitutional theory. Instead, everything unfolds on the side of the road, often late at night, with cars rushing past and flashing lights reflecting off the pavement. Yet behind that ordinary scene lies more than a century of legal history. Court decisions stretching back decades have slowly shaped the boundaries of what police officers can and cannot do during traffic stops. Each case, each ruling, each legal debate has added another layer to the framework that governs these encounters. The automobile exception, born during the era of Prohibition, recognized the unique mobility of vehicles and allowed warrantless searches when probable cause exists. The Terry decision acknowledged the real-world dangers officers face and permitted limited pat-downs for weapons when safety concerns arise. Cases like Pennsylvania v. Mims and Maryland v. Wilson established that officers may order drivers and passengers out of vehicles during stops for safety reasons. More recently, decisions like Rodriguez v. United States have reinforced that traffic stops cannot be extended beyond their original purpose without additional reasonable suspicion. Together, these rulings form a legal structure designed to balance two powerful interests. On one side is the responsibility of law enforcement to protect the public, enforce traffic laws, and investigate potential crimes. Roads are shared spaces used by millions of people every day, and safety on those roads matters. Drunk driving, reckless behavior, and criminal activity can pose serious risks to everyone traveling those highways. On the other side is the constitutional promise that individuals should be protected from unreasonable government intrusion. The Fourth Amendment was written with the understanding that power must always have limits. Without clear boundaries, even well-intentioned authority can become excessive. Traffic stop law exists in the space between those two principles. It attempts to create rules that allow officers to do their jobs while ensuring that individual rights remain intact. But here is something important to remember. The law does not operate in isolation. It exists within real human interactions. Every traffic stop involves people. An officer performing their duties, and a driver trying to navigate an unfamiliar situation. Both sides often carry assumptions into that encounter. Some drivers assume police officers have unlimited authority during a stop. Others assume officers have almost no authority beyond writing tickets. The reality lies somewhere in between. Understanding that reality can change how people experience these moments. When drivers understand that officers can legally ask them to exit a vehicle, the request may feel less surprising. When drivers know that a traffic stop must remain reasonably tied to its original purpose, they may better understand the flow of the encounter. Knowledge does not eliminate the stress of a traffic stop, but it can reduce the uncertainty, and uncertainty is often what makes these encounters feel intimidating. Think about how different an experience can feel when you understand the rules governing a situation. When the boundaries are clear, people tend to feel more confident and more calm. That clarity is one reason why conversations about legal rights remain important. Not because every traffic stop turns into a legal dispute, but because informed citizens and accountable institutions strengthen the overall system. Another interesting aspect of traffic stop law is that it continues to evolve. Technology, changing laws, and new legal questions constantly reshape how courts interpret these situations. The increasing use of body cameras, dashboard cameras, and digital evidence has transformed how traffic stops are documented and reviewed. Video recordings now play a central role in courtrooms across the country. Judges and juries can watch interactions exactly as they happened, rather than relying solely on written reports or testimony. This level of transparency has changed the legal landscape in important ways. It allows courts to analyze the precise timeline of events. When did the stop begin? When were documents requested? How long did the officer take to complete the traffic citation? Did the stop extend beyond the time reasonably required to address the violation? Questions like these once depended heavily on memory and interpretation. Today, they are often answered by video footage. At the same time, legal debates continue over new issues. How should the law treat advanced license plate readers that automatically scan vehicles? What about automated traffic enforcement systems? How do evolving marijuana laws affect probable cause standards during vehicle searches? Each of these developments forces courts to revisit the principles established decades earlier and adapt them to a modern world. And that process will likely continue for many years. Because traffic stops sit at the crossroads of technology, law enforcement, and everyday life. Millions of people drive every day. Millions of interactions between police officers and drivers occur every year. Each one operates under the same legal framework, yet every encounter unfolds differently depending on the circumstances. Some stops end with a simple warning, others result in citations. Occasionally, a routine stop reveals evidence of more serious crimes, but most encounters remain brief and uneventful. Still, the underlying legal structure remains important precisely because these interactions are so common. When something happens millions of times across a society, even small rules can have large consequences. So the next time you see flashing lights in your rearview mirror, or even just think about the possibility, it may help to remember something simple. A traffic stop is not just a moment of enforcement. It is also a moment where constitutional principles quietly come into play. The officer approaching the vehicle carries legal authority shaped by decades of court rulings. The driver behind the wheel carries rights protected by the Constitution, and the encounter that follows is guided by rules designed to maintain a careful balance between those two realities. Understanding that balance does not mean challenging every officer or turning every roadside conversation into a legal debate. In fact, most traffic stops remain straightforward because both sides understand the basic expectations of the interaction. But awareness of the law helps people recognize the structure behind the moment. It reminds us that even everyday experiences, like being pulled over on a quiet road, are connected to deeper ideas about freedom, authority, and accountability. And perhaps the most important takeaway from all of this is surprisingly simple. Knowledge creates confidence. When people understand the principles governing their rights and responsibilities, encounters with authority become less mysterious and less intimidating. So now that you've explored the legal framework behind traffic stops, here's a final question to think about. Before watching this discussion, did you believe police had more authority during traffic stops than they actually do? Or less? And has your perspective changed after learning how these rules really work? Share your thoughts and experiences in the comments. Many people have stories about traffic stops, some routine, some unusual, and some that raised questions about what the law allows. Those conversations can help others better understand how these encounters unfold in the real world, because the more people understand the law, the more transparent and balanced the system becomes for everyone who shares the road.